Okay, good day. So today we're going to discuss the legal issues and related to recruitment and selection. So this topic is under the PhD EM 709, subject Human Resource Management Models and Practices. So under the supervision of our professor, Dr. Joel Aguilan. Okay, so I'm Sarah Katrina de Mesa-Portes, going to present this and tackle this topic. So first is, what are the learning objectives? So we're going to define the legal issues in recruitment and selection, understand the different law and legal basis related to recruitment and selection. So let's define. So what is legal issues? So legal issues or issue of the law is a legal question which is the foundation of a case. So it requires a court decision. It also refers to a point of which an evidence is disputed, an outcome of which depend on a court's interpretation of a law. Basically, legal issues is the loopholes of a particular situation that need a court to decide whether it is based on legalities. Okay? So, it is the evidence dispute. Okay? Kailangan disputed, which means is evidence-based. Okay? So, second is recruitment and selection. So, according to the dictionary, recruitment and selection is the process of identifying the need for a job, defining the recruitments and requirements of a position and the job holder. So, advertising the position and choosing the most appropriate person for the job. So this is the terminologies that we need to know. So all of us have already encountered recruitment. So the HR supervisor or the HR manager or the selection or recruitment supervisor or manager are the person who are involved in the process of recruitment and selection. So, lahat ng professional, even worker na nagtrabaho, this is the first phase, okay? They are selected for a particular position. So next is the Department of Labor and Employment or the Bureau of Labor Relations. So this department are the governing body of the process. So sila yung nag-oversee na nasusunod ba ang proseso pagdating sa labor and employment, especially in hiring. Okay? So, the Labor Code of the Philippines stands the law of governing employment practices and labor relations here in the Philippines. So, it was enacted on the Labor Day of 1974 by former President Ferdinand Marcos in the exercise of his then extant legislative power. So, it prescribed the rule of hiring. Okay? So, most probably, I will focus my discussion on the hiring process since the topic that I was assigned is more on the selection and the recruitment. So, however, labor code also tackle about not only the hiring process, the termination of the private employees and the condition of work, including the maximum work hours and overtime, employees' benefits such as holiday pay, 13-month pay, and retirement pay, and the guidelines of organization and membership in labor union as well as the collective bargaining. So, the Department of Labor and Employment focuses on the private employee, okay? So, that are hired or working for the private institution, private industry, or company. On the other hand, the governing power or the government employees are handled by the civil service, like DepEd, working as a in the teaching profession in Department of Education, so and other government office. Okay, so under kami ng civil service, while the private is under the Department of Labor and Employment. Okay. So, what are the main statuses and regulation relating to employment? So, the Labor Code of the Philippines, or the Presidential Decree number 442 as amendment, is the Labor Code. And this omnibus rule implementing the Labor Code amended are the main employment statuses and regulation in the Philippines. So, recruitment and placement refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, and procuring workers, and includes referral, contract, service, promising, or advertising for employment locally and in the Philippines. Locally in the Philippines. Or pwede din siya sa abroad, whether for profit or non-profit. But the recruitment in the Philippines is governed by the Labor Code, while the recruitment for the work abroad or the OFWs is governed by the Migrant Worker and Overseas Filipino Act, Republic Act number 8042 as amended. So the rules of legitimate job contracting mentioned in question 13 also provide for the temporary assignment. Temporary, okay? So not a regular employee of a worker of the duration of service agreement, or only for a piece of a job or work to be undertaken. So the job contractor recently, as announced by our President Rodrigo Duterte, are prohibited from engaging recruitment and placement activities. So, according to the Department Order number 174 series of 2017, this is a very recent department order. So, pinagbabawalan or prohibited, binagbabawalan ang mga job contractor na mag-join ng recruitment, for example, ng job fair, kasi nga, they are hiring people not for regularization. Okay? Ibig sabihin, contractual lang. Hindi sila mare-regular. Every 5 months or every 6 months, for renewal yung contract. Okay? So, that is prohibited by Department Order 174. So, legal issues in hiring. At every stage of hiring process, employer must be careful not illegally discriminate against an applicant for a position. So, since discrimination is prohibited on the basis of the race, the gender, the national origin, the age, religion, and disability. And by now, most of the job applicants know that. Okay? So, magagaling at matatalino na yung ating mga job applicant. Alam na nila kung ano yung right nila, even though hindi pa sila na-hire sa company na ina-applyan nila. Any indication of bias in hiring process might lead to serious legal prosecutions. Okay, so the Labor Code prohibits discrimination against women on account of their gender, of their age. So, according to the Magna Carta of Women, okay, Republic Act number 9710 as amended, prohibit discrimination against women and expressly impose liability for damage on the person directly responsible for such discrimination. Okay, for example, you don't hire a particular person dahil babae siya. Okay, that is a big no-no under the Magna Carta of Women. So, bawal natin hindi i-hire or i-discriminate, wag bigyan ng chance for employment ang mga kabataan dahil lang babae sila or according to their gender. So, lalabag ka sa Republic Act number 9710 and you are going to have any liabilities. Meron kang sanction according to this law. Okay? So, the Anti-Age Discrimination in Employment Act or the Republic Act number 10911. So, prohibit discrimination on account of age and impose penalty for the violation of the act. So, the first one is discrimination against gender, especially for the women. And then this second act is the anti-age discrimination. According to this law, it was signed into a law to promote equal opportunity of employment for everyone. So the act encouraged the employer to hire individuals on the basis of their abilities, knowledge, skills, and qualification rather than their age. Okay, so it likewise prohibit arbitrary age limitation in employment and advance the right of all employees and workers regardless of age to be treated equally in terms of compensation, benefits, promotion, training, and other employment opportunities. So, if meron kang mga program and then benefits, promotion, kailangan there are equally distributed. Pwede siya kahit saan age. Okay? Hindi ka maglalagay ng for promotion if certain age are there is a certain age. So that is prohibited under the Republic Act of 10911. And another thing is for your job posting. So if you're an HR manager, so nagkaroon kayo ng job posting through online or internet in your social media account na you're hiring, for example, a medical technologist in your hospital, ages 21 to 30 years old. So, you are violating the Republic Act 10911 or the Anti-Age Discrimination. Okay? So, kailangan you hire your people or your employees according to their abilities, knowledge, skills, and qualification. Okay? So, rather than their age. So, what are the enforcement remedies to exist? So, an employee or prospective employee who claim to have been discriminated on the basis of age may bring a suit, pwedeng kasuhan, against his or her employer and invoke the right. So, ito yung pwedeng penalty. So, any violation of an act shall be punished with a fine of not less than 50,000 but not more than 500,000 pesos. Pwede yun. So, second is, pwede din magkaroon ng imprisonment of not less than 3 months but not more than 2 years. Or, pwedeng both ang iyong sanction. So, at the discretion of the court, pwede parehas. If the offense is committed by a corporation, a trust, a firm, a partnership, or association of other entity, the penalty shall be imposed upon the guilty officer or officers such as corporation, trust, firm, partners, or association or entity. Okay? So, in addition to the act mandates in the Philippine Department of Labor and Employment or the DOLE. So, DOLE should conduct studies or pwede partnership sa mga HR, research on minimizing impediments to the employment of older person and furnish such information to employer, labor group, and general public. Second is promote programs, so trainings, okay, or seminars about age equality, for example, opportunities in coordination with public entities and private entities or agency that will further enhance the knowledge and skills of every individual regardless the age. So what are the exemption? So the exemption in here is the act may appear to be too restrictive, but it still admits several exemptions. So may exemption to the rules pa din. As a rule, it is not unlawful for a covered person or entity to set an age limitation in employment if age is a bona fide occupational qualification reasonably necessary in the normal operation of a particular business, or whether the differentiation is based on a reasonable factor rather than age. For example, ang reasonable factors mo is physical strength ka. Okay? So, pagdating sa age, nagiging another variables na siya na hindi mo siya ma-hire kasi nga hindi siya fit for the position kasi kailangan ng physical strength. Okay, that is an exemption. So the intent is to observe the terms of bona fide seniority system that is not intent to invade the purpose of the act. The intent to observe the terms of a bona fide employee retirement or a voluntarily early retirement plan consist with the purpose of the act and the action duly certified by the Secretary of the Dollar. Okay? So the Republic Act number 7277 as amended, or the Magna Carta for person with disability. So this Magna Carta provide that a qualified employee with disability shall be subject to the same term and condition of employment as qualified able-bodied person. For example, way back 2014, 11 to 2014, I was connected before in East Hardware Philippines Corporation in SM City, Lucena. And one of the employee in the cinema department is have this disability. Okay, usually it is his legs, and then meron siyang polio, kaya yung legs niya, meron siyang disability, physical disability. However, she is qualified for the position of being a maintenance siya, and then at the same time, nilalagay siya sa elevator, yan. Sa elevator, to operate the elevator to all men and goes to yung batan lang, yung operate lang. So, qualified for the job, even disabled siya. So, kung another thing, not during the hiring process, kung na-hire na yung inyong na-hire mo na yung employee mo, and then meron siyang disability, then terminate mo siya. So, that is against Magna Carta for person with disability. Okay? Okay. Another Republic Act number 8972 is the Solo Parents Welfare Act. So, this act prohibits an employer from discriminating against any solo parent employee with respect to the terms and conditions of employment on account of the employee being a solo parent. So, hindi mo tinanggap yung employee mo, yung nag-a-apply sa'yo kasi solo parent siya. Okay? And then, sinabi mo sa kanya, hindi ka namin ma-hire kasi solo parent ka. Okay? That is a form of discrimination. Okay? So, that is against the Republic Act number 8972. Next. So, the Republic Act number 8371. So, the Indigenous Peoples' Rights Act. So, prohibits discrimination against indigenous cultural communities or indigenous people with respect to recruitment condition of employment on account of their descent. So specifically, yung mga brothers natin and sister, for example, is Aitas, Bajau, Mangyan, okay? So, hindi mo sila binigyan ng chance to be hired kasi badyaw sila or mangyan or kung anong indigenous people sila or kung saan silang group kasali. And then nalaman nila o kaya naman is yung sinabi mo reason, so you're violating the Indigenous People Rights or the RA number 8371. So next is the Republic Act number 11166 or the Philippine HIV and AIDS Policy Act also prohibit the rejection of job application, termination of employment, and other discriminatory policy in hiring, provision of employment and other related benefits, promotion of assignment of an individual solely or partially on the basis of actual perceived or suspected HIV. So, bawal tayong as an employer, so hindi mo siya i-hire particular person mo dahil, although qualified naman siya for the position, dahil pagdating ng kanyang, for example, is laboratory or medical examination is nag-positive siya sa HIV, then you-reject mo siya. So, lumalabag tayo sa Republic Act number 11166. Or pwede din na employed na yung iyong employee mo na siya. And then, during your annual physical exam, nalaman mong positive pala si Miss A. And then, inaano mo siya na mag-resign or ma-terminate due to positive HIV and positive siya sa HIV or AIDS. So, that is against the law. Okay? That is prohibited. Okay? Yeah. Okay, next is the Republic Act also, in continuation, and this law also states that the policy of practices that discriminate on the basis of perceive pa lang, pinaghihinalaan mo pa lang siya na HIV positive, so status, pwedeng sex, gender, sexual orientation, gender identity, and expression, age, economic status, disability, ethnicity, are deemed inimical to nation's interest. Okay? Next is the Sotto Bill. So this is a very recent bill, the Sexual Orientation, Gender Identity Expression. So for the passing of the Sotto Bill, Equality Bill is even more pertinent. So this bill seeks to prohibit employer from imposing SOGE in their criteria for hiring, promotion, transfer, designation, dismissal, selection for training, privilege, and more. With such a bill in place, the company will be legally obligated to shift to more inclusive culture. So, hindi mo hinaring nag-apply sa'yo kasi meron siyang, halimbawa, transgender or gay or belongs sa LGBTQ, and then yun yung sinabi mong reason kaya hindi mo siya ihahar, so you're violating the Sotto Bill. Okay? So, how common are claims? How common are these claims? So, claims relating to discrimination in the Philippines or the application in process are very rare. So, rare siya sa Pilipinas. Hindi usually nagkakaroon ng complaint pagdating sa discrimination upon hiring here in the Philippines. Prior to the enactment of the Act, in the view of the prevailing rules that the employer is free to regulate. So, an employer is meron siyang sariling policies, rules, and regulations. So, according to this discretion of the best business judgment, all aspect of employment from hiring to firing. So, except in case of unlawful discrimination of those which may be provided by the law. Okay, so even though that the employer have this free to regulate the rules and regulation in terms of hiring, we at the HR manager or management, so we need to know when not to discriminate a person. Okay? Because discriminating a person can be against the law. Okay? So, magkakaroon lang tayo ng problem. But, again, sinasabi din ng batas na merong ang employer na sariling rules and regulation. Okay? So, claims relating to discrimination during employment are more common. Discrimination during employment usually leads to cases aligning constructive dismissal. Constructive dismissal is a cessation of work because continued employment is rendered impossible, unreasonable, or unlikely when there are demotions in rank or demotion in pay. So, or both, pwede parehas. Or when there are clear discrimination, insensibility, or disdain by the employer because of unbearable to the employee. In deciding these cases, the court will usually apply use of the test of whether a reasonable person in the employee's position would have felt compelled to give up his or her employment position under the alleged circumstances. Discrimination is always illegal, okay? Even subconscious or unconscious discrimination. When we talk about unconscious discrimination, kahit hindi mo sinasabi, nararamdaman nila, okay? ng ating employee or applicant. So, employer need to keep a close eyes on every policy, procedure, practices they perform. Whether you deal with this prospective, current, or past employee, you cannot discriminate in any aspect of your pre-employment, current employment, or post-employment action and decision. Okay, so for that, this is my reference. If you have any question, email me in my email account, personal email account, demesa.saki@gmail.com. I hope you learn a lot from this topic, from recruitment, the legal basis, the legalities, or the issues in hiring. Hi, that's all. Thank you.